All right. Please be seated. Okay, welcome to an oral argument section of the Sixth District Court of Appeal. My name is Judge Joshua Mize. To my right is Judge Pedro Brownlee. To my left is Judge Roger Ganem. We have one case on the docket for today. It's a consolidated case, 23-1797 and 23-2439. It's Joseph Formica versus Teresa Formica. Is everyone ready to proceed?
Yes.
Appellant, please approach.
Appellant.
I'm sorry. Yeah. I know.
Oh,
I said appellant. No, you're good.
Thank you.
Counsel, how much time would you like for rebuttal?
5 minutes, please.
Okay, please proceed.
May it please the court. My name is John Gilhart. I'm from Family First Legal Group. I represent the appellant and cross appellee, Mr. Joseph Formica. Today we are requesting that this court reverse and remand the omnibus final order that was entered by the trial court and the subsequent fee order, and remand it with instruction to correct the findings in the order and provide the court discretion to either hold a hearing or not, considering the amount of time that has passed since the final trial and the subsequent fee hearing.
Counsel, can we correct a lack of findings in the order if there was no motion for rehearing that was timely filed?
Excuse me, can you repeat that?
So in the final order, you're saying to correct the findings. If there's an absence of findings or a lack of a specific finding that you're going to address, can we even consider that without a timely filed motion for rehearing?
I want to clarify the relief. I'm requesting the court remand it to the judge to make requisite findings.
Okay, so isn't there a rule though of procedure that would require if there's a lack of findings, the motion for rehearing?
Yes, I agree with that. Yes.
Okay, and was that done in this case and was it timely?
I believe the motion for rehearing as it relates to the omnibus final order was timely. Yes.
Okay.
As it relates to the attorney's fee provision, I acknowledge that we filed our motion for rehearing 1 day late. However, it was after Mr. Shempus's office had filed their motion for rehearing within the 15-day time for the rehearing. And our position is that told the rendition of the order.
Is there any case that says that?
I don't have a case, Your Honor.
So the rule said you had 15 days to file a motion for hearing, right?
From the date of the order.
Correct.
And the rules also state that
what time's the rendition for purposes of the appeal, right? But there's no rule that extends. It doesn't say, as far as I'm aware, there's no rule that says it extends your deadline to file a motion for a hearing just because they file a motion for a hearing. Like, for instance, their motion for a hearing could have been pending for 6 months, depending on how long it took to get a hearing. Are you saying during that whole time you had the right to file a motion for a hearing?
I believe so, Your Honor. And during that entire time, the rules of family procedure would permit them to amend it with the court's discretion during.
Well, yeah, but there's a separate provision saying that once you file with court's discretion, right, you don't have a right to amend it. A court can allow you to amend it, assuming you filed it timely. So under your interpretation, if one side files a motion for a hearing, until that motion is ruled on, the other side just has an unlimited deadline to file their own motion for a hearing?
I believe so, Your Honor.
Is there any case ever saying that?
I could not find a case that says that. There are parallels in the appellate rules, though, that do say when the appellate court renders a ruling that it does toll the rendition as to all parties. That's within multiple different sections of the appellate rules that I've cited in my case or in my brief.
I don't need to belabor it. Go ahead.
Okay. As to the issues related to the omnibus order, Your Honor, before I forget, we filed a motion for appellate fees in this case, and as part of our requested relief, we're seeking that be remanded to the trial court for determination, consistent with 6116. But as it relates to the issues of the omnibus final order, there are 4 main issues, and the main 2 sort of cascade into the others. The first issue is that the trial court adopted the mother's proposed order verbatim, and the language is contrary to some oral pronouncements that the court made. It gives the appearance that the court failed to exercise its independent judicial analysis. The second issue is that all of the request of relief that was pending before the court, it's our position, all of it was related to the best interest of the child or was related to a parenting dispute. And therefore the court was required to make best interest findings, and nowhere in the omnibus final order was there best interest findings. And there was some language about what the parties believed was in the best interest of the child. The court was reciting the facts.
So counsel, I was interested in that argument in terms of whether this is a enforcement action or not, because, you know, I was a family court judge, and the provision that you're referring to basically said, you know, there's a catch-all provision that says all time sharing and custody determination should be made according to the best interest of the child. It doesn't say where you're making those decisions, right? And then there are specific provisions, you know, governing final judgments and the fact that they're made on best interest. That would seem to me, and I take the appellate's point in their briefs, that that's really the specifics of how you do those, and the specific controls over the general. If I were to take your interpretation that anytime you're filing a motion for contempt, a failure to comply with the final judgment, you're making best interest findings on whether to enforce the final judgment, that would essentially mean every final judgment can be modified without a petition to modify it anytime somebody files a motion for contempt, which is seemingly directly conflict with the provisions requiring you to file a petition to modify in order to modify a judgment.
I think it would depend on the relief that's requested, whether it is a motion for enforcement or a modification, just because you're requesting.
But you can't file motions for modification. That's my point. The rules require you to specifically require a petition and basically start a new lawsuit within a lawsuit. So you didn't file a petition to modify, right? There was a motion for enforcement, and to the extent motion seeks modification, it's a nullity. That's not a thing. There are no motions to modify permitted under the family law rules.
I agree.
So for you to say that that kind of catch-all provision means that every enforcement proceeding requires best interest findings would really mean anytime there's a motion for enforcement, it can result in a modification, right? Because you're going to do a best interest analysis as to whether to actually apply the final judgment, which would seem to me, to make final, as a practical matter, make final judgment never final, right? You could never know whether they were going to be enforced, because you never know if the judge will say, well, I'm going to change it. And it would seem to specifically conflict with the provisions of the rules, specifically requiring a petition to modify to be filed in order to modify a final judgment. It would seem to clearly allow modification without a petition to modify.
I think, Your Honor, in requesting enforcement, though, yes, you have to do a best interest. I still certainly you have to do a best interest finding for all enforcement related cases if the issue is about parenting. And because if you're going to enforce a judgment, you need to contemplate the consequences that might have on the child.
So you're agreeing every single time someone sought to enforce a final judgment for which a judge has already done a best interest analysis when they made the final judgment, it would always be fresh. Should I enforce this final judgment, or should I do something different based on the best interest?
No, Your Honor, I am stating that in entering the relief that is requested in the motion for enforcement, if it's a request for a modification of the judgment, I would agree you need to prove a substantial change in circumstances. But if the request is to enforce provisions of it, and the court is going to enter some type of relief that is requested, they need to consider how that relief is going to impact the best interest of the child.
So counsel, it seems like you said you disagree with my analysis, but then said it would be exactly how I said it was. If you're saying that anytime somebody brings an enforcement action of a final judgment that's already been entered and that is final, the appeal deadline is passed, the trial judge does a fresh best interest finding. Should I actually enforce it or should I not, based on what's in the best interest of the child? How is that not in effect the modification? If the trial judge is going to say, I'm not enforcing the final judgment, I find it shouldn't be enforced, how is that not in effect the modification of the final judgment?
I think it depends whether or not the relief you're requesting is a modification. Some of the case laws interpreting some of the requests, if it's a modification request, you need to plead for substantial.
But how is a modification different than don't enforce it because I think it's not in the best interest? Isn't that in effect, like you're making this distinction between enforcement and modification? If it's a motion for modification, that's just not a thing. I don't think you've disputed that. That's not a thing. That's not a thing you can do. So you've said that twice and it doesn't exist. So please go somewhere else because it's not helpful. If you're bringing an enforcement action, if you're asking the judge, I know you can't modify this, but just don't enforce it because I don't think it's in the best interest. What else could a best interest finding be there other than to whether or not enforce the final judgment? And if you are deciding whether or not to enforce the final judgment, how is that not an effective modification to just say, I'm not going to enforce it. I don't think it's the best interest anymore.
Well, Your Honor, I think when enforcing the final judgment,
Is it true that there's just no good answer to that question, counsel?
well, I disagree. I think the court still needs to make a best interest finding.
Why?
Because whatever the court decides to do is going to impact the child, like the case I cited, the Linsky
Okay,
case.
but do you disagree that if you decide not to enforce a final judgment based on some best interest finding, that is essentially modifying the final judgment? It is saying this provision of the final judgment is not going to be enforced.
I don't see that as a modification because the final judgment still stands, but under those
You're
circumstances.
just going to say this provision, all right, final judgment has 5 provisions, section 5 not enforced from now on. That's not a modification of the final
Not
judgment.
necessarily from now on. There could be at the time a best interest standard. For instance, the attorney fees. I cite to the Linsky case that references attorney's fees, and the court needs to contemplate when
But attorney's fees don't involve whether a final judgment is being enforced, counsel. So you're saying each time you go before the judge, it should just be on an enforcement action. It should just be a fresh dispute. Is this final judgment going to be enforced or not? Every single time.
if the issue is one of parenting. Yes, I think
Okay.
so.
Does it occur to you that that would append all of the family courts and every family law litigant in the state? Because no one would ever know if the final judgment would be enforceable. Because anytime somebody said to their, former spouse or co-parent, hey, this is what the final judgment says, they could just say, I don't think it's in the best interest. And even though that's in there, I don't think that's what a judge would say now. So I'm not going to do it. Let's go to court. How many best interest how many more enforcement actions would we see based on just, I don't think it's in the best interest, if everyone knew every single enforcement action was essentially a new proceeding where you had an entire new opportunity to argue whether the final judgment was in the child's best interest?
I don't know, Your Honor. I'd be speculating. I'm looking at the case law that I cited that mentions bring those up. For instance, when the court is breaking an impasse between the parties over schooling.
But that doesn't modify a final judgment, right? That enforces that. So when you have shared parenting and it says every decision that's a major decision the parents have to agree on, you're not enforcing or not enforcing the final judgment. You are implementing it, because if they don't agree, it goes to the judge. That is completely different than saying this provision of the final judgment that is clear, right? And that which has already been decided is a free-for-all every time anyone wants to enforce it. You admit those aren't analogous at all, correct?
Well, I suppose it would come down to a case by case basis on what impact the decision, whatever you were attempting to enforce, whether it has an impact on the child or not.
Yeah, so it'd just be a new proceeding. Is this in the child's interest each time to enforce the final judgment or not?
I suppose yes.
Okay,
Yeah.
all right.
Counsel, in this case, on the school issue, there was a December 1st, 2022 partial order entered just to, as I understand it, because there were some deadlines coming up in the court when to get that part out first. And that order does make a finding that picking one of the schools off the mother's list or picking the mother's choice of schools in the order that she presented them is in the best interest of the minor child. That order also said that it contemplated that the court would enter a future order amending or replacing it. But the omnibus order doesn't say anything about the partial order that I can find. So does that record finding in the partial order, is that still part of our record? In other words, isn't there a finding of best interest that is on the record on the school issue?
I don't have a case law to support this, but it doesn't seem to be, as the court entered a subsequent order that essentially replaced that order. And that order was a result of, I think it was Mr. Shemkus contacting the judicial assistant about the impending deadline, requesting the court expedite the order so we get some clarity. And we submitted that order. That was an agreed order between Mr. Shemkus and I. And then the court, and that was while our competing proposed orders were pending. And then when the court entered its order, it completely replaced any best interest finding, made no best interest finding, and interpreted the schooling issue strictly on contractual provisions and didn't determine the best interest.
Well, that's just counsel. The best interest finding can be made orally, right, at a hearing. Why could they not be made in an interim order? Because there's no rule that best interest findings have to be in the final order. They just have to exist, right? So for instance, the case law is clear, a judge can make them on the record, right? The judge can orally make the best interest findings. And then in his order, just give the actual, here's what we're going to do. And the best interest findings made orally at the hearing are sufficient, provided they were made. If you can make them orally at the hearing before issuing an order, why can you not make them in an interim order?
I suppose you could if the court was going to indicate in the order that this order stands and we'll send and the second order is just an addition to it, but it doesn't seem to be that's what the orders did. It was this will be amended or replaced, and then there was a subsequent order that completely replaced it. So it doesn't appear that that order, I guess, is still valid.
Another question for you regarding the school issue of, I understand your argument about the court's interpretation of the school provision. That the word school should include homeschool as proposed by Mr. Formica. However, if the court interprets the word school in the agreement to mean a brick and mortar, an institutionalized school, however you put it, in other words, something other than the home, wasn't the judge required, if the judge interprets school to mean that, wasn't the judge required to pick one of the schools proposed by the mother, given that the father didn't propose any? In other words, wasn't the judge's discretion at that point limited to picking a school that had been proposed, as opposed to engaging in sort of a de novo analysis of where the child should go to school?
I don't know that I understand the question.
Well, the mother proposed a list of schools.
Yes,
and the father proposed homeschool.
Yeah.
The court interpreted the school provision in the agreement to require each of them to propose a physical school for the child to go to. Once the court concluded that's what the provision meant, you have then the mother had submitted schools and the father had not. Wasn't the court's discretion at that point confined to picking one of the, picking a school that the mother had proposed, as opposed to going outside of that?
I under the circumstances of this case, I think allowing the list of schools proposed by the mother was appropriate, just because it was an application process that had to happen. So we didn't know which ones would be accepted. It was voluntary pre-kindergarten. It wasn't a public school. It was pre-kindergarten situation. And if I recall, my client did testify as to some agreement as to if school was to be institutionalized, he was in agreement to the list in some capacity. I don't remember. He had a different proposed order of the ranking. Ultimately, I think the court should have awarded ultimate decision-making over the issue of that. That's something the court did. The court ended up just picking the mom's list of schools.
Can I ask you about this, the calling the name of the stepfather issue? And I know the argument was that violated the, prohibition on either party hampering the natural development of the child's love and respect for the other parent. Are you asking us to reverse that portion because the trial judge didn't make sufficient findings on that issue, or because he misinterpreted the meaning of that provision?
I want to clarify.
I guess I'm asking, are you asking us to, is it a legal error in interpreting that portion of the parenting plan? Or is it a, failure to make findings that supported his ultimate conclusion?
A failure to make findings that are in the best interest of the child.
So you don't assert he made any legal error in how he interpreted the provision in terms of its legal meaning?
My understanding was it was your position that it violated like paragraph 3.1, I think, of the parenting agreement. Is that correct?
Yes, it was. She was failing to encourage and well, it was ultimately undermining the father's relationship, and the parties had a duty to facilitate and encourage that relationship between the parents and the child.
And so is it your position now that when interpreting that, the trial judge made an error, or as Judge Mize just suggested, it's just the lack of best interest findings related to that portion of the claim?
I think it's probably both. Off the top of my head, I can't remember the legal error. I think the judge, I think foundationally problematic to this entire case is that the judge didn't exercise his independent judicial discretion in any way, shape, or form, and simply signed Mr.
Well, hold on, Kel. That goes back to the issue of whether he improperly entered a proposed order that consideration. That's completely separate from Judge Brownlee's question. Answer the question.
I would have to I just don't remember off the top of my head about the brief. I'm asserting he didn't make the proper findings. As it relates to that issue.
Okay, thank you.
I understand we're
I do want to answer all the questions,
Yeah,
so.
I should have told you under your rebuttal time,
Yeah,
but
I noticed, yeah.
I'll give you a couple minutes for rebuttal. You got 40 seconds left now. Do you want to preserve the rest for rebuttal or you want to keep going?
If there's, I want to answer all the court's questions, so.
I just want to pose this question. Some of the litigation has focused on this language in 2.1 of the parenting plan. It says the parents agree to use their best efforts to cooperate in such matters, and that any rights, duties, or responsibilities set forth herein shall not be exercised to frustrate or control the other parent. Now, it occurs to me that where you have, in any situation where you have one parent who is willfully not performing the agreement, and the other parent brings an action to enforce the terms of the agreement, in every case, that's going to, potentially frustrate the other parent who wanted not to perform and seek to control that other parent who isn't performing, and you're trying to get that parent to perform. So apart from, simply the act of, bringing an action to enforce the agreement, how do we interpret when is there a breach or a violation of that provision that the parent agrees, not to, try to frustrate or control the other parent?
I think that's a case by case basis. It's almost like a bad faith, I suppose, analysis, because in the situation of these circumstances, my client was an hour late with his notice for the vacation time. So I do think that in the court, in its oral pronouncements at the end of trial, did state that this was not in the child's best interest. The father was denied a 2-week vacation because of an hour delay. And I think that is a perfect example of when it's being frustrated. The parent plan is being used to frustrate the other parent's rights. And the court did go on to say, he may not be a timely guy and to give him 2 weeks. I don't know that I necessarily agree with 2 weeks. That might be a little too long, but I think it's more or less, is this parenting plan being followed in bad faith? That would be when it's not being followed in bad faith. And that would be when it's frustrating the other parents' rights.
Your time is expired. I'm going to give you 2 minutes for rebuttal, and I'll add the same amount of time to appellate's main argument.
Appreciate it. Thank you.
Michael Shemkus on behalf of the former wife, Ms. Teresa Virgo. May it please the court. Your honors, I'd like to start kind of out of order for a moment and start with the order on attorney's fees first. I'm relieved to hear that the court, at least Judge Mize is of the opinion, Judge Brownlee is of the opinion that 12.530 means what it says. That in order to preserve a complaint or a challenge to an order based on an insufficiency of findings, the party must file a timely motion for rehearing. It wasn't done here. And so it's our position that that argument has been waived. And without that argument, there is no reversible basis on the appellant's side for that order.
Which issue? Go through the issues. Which ones do you think were waived for the lack of a motion for a hearing?
The order on attorney's fees, specifically the arguments that it lacked the requisite findings of fact.
So just the attorney's fees issue, then, correct?
Yes.
Okay, you don't assert that the other issues weren't the subject of a valid motion for a hearing based on lack of findings?
If we're talking about the omnibus final order, correct. I'm not making that argument.
While we're talking about attorney's fees, let me just ask you about your client's claim for contractual attorney's fees. As I understand the language, and you're familiar with it, if either party sues the other party as to any alleged breach of this agreement. Just focusing on Ms. Virgo's claims against Mr. Formica, it is asserting the failure of Mr. Formica to propose a school for the child to attend. Is that really a breach of the agreement, or is that just simply the failure of a conditioned precedent to his right to have a say so?
And also, is it a suit? So when somebody sues the other side, filing a motion isn't a suit. It's a part of a suit.
I don't know the answer to that question, Ron. I don't know what the definition is of suit.
Well, could that language be fairly interpreted to mean a new lawsuit as opposed to just a motion in this case, is I think what Judge Mize might be getting at.
Well, I don't think well, I suppose that would be a breach of contract would be the cause of action.
Well, let me ask you this. So if somebody, if your client wasn't currently in litigation and somebody, another lawyer contacted you and said, hey, I filed suit against your client, would you accept service? You'd call your client and say, hey, you've been sued, you want me to accept service, right?
Yeah, I would say
If
that.
you were already in a lawsuit with a client, okay, and the other party sends you a motion, would you call your client and say you've just been sued?
I might, but that's my own ignorance, I suppose, of the term suit. Honestly,
Really? You'd get a motion in litigation,
Honestly.
you'd call your client and say, every time you got a motion in a lawsuit, you'd call your client and say, you've been sued? So in other words, there's 40 motions in the lawsuit, your client got sued 40 times?
I might, Your Honor. In 10 years of practice, I've never debated with anyone the definition of suit.
Have you ever said to a client when you received a motion from the other side in a lawsuit, you've been sued?
I have, Your Honor,
Okay,
and I may have been wrong.
So if the language says, I think it says sues, just so but if the language says, if either party sues the other party as to any alleged breach. Can you just talk about this though? Because how is what your client did effectively suing the other side for an alleged breach?
Absolutely. The motion for enforcement and or in the alternative to break parental shared parental responsibility impasse was brought at a time when it was unclear to us whether the court, the trial court, was going to interpret the school issue on an enforcement basis or as on a breaking a shared parental responsibility impasse basis. And why that was confusing at the time is because, and this, I don't think this is argued in any of the briefs, but I believe that there is two camps of appellate decisions that exist right now that are not in harmony on this issue. I think you can find between 2 and 3 that read very much in the way that Mr. Gilhart had argued at the trial, that when two parents are at odds over a shared parental responsibility decision, that the court acting in its enforcement capacity, well, acting in a capacity at all, has the duty to break the impasse by just picking a school. There's a couple of decisions that say that. There are also other decisions that say that in order to accomplish that goal, the court has to grant ultimate decision-making authority. And we argued that was not the proper course of action. It had to be brought in the way of an enforcement. That this was an enforcement power that the court possessed, and specifically, we argued that what was so frustrating from Ms. Virgo's perspective is that she thought that she was complying with the agreement. She was presenting the names of schools, and for months she was met with nothing but homeschool only, and she felt duped. And she thought, this is not what we had in mind. This is not how this was supposed to go. I was supposed to receive schools back from you, not some other category of educational setting. And so eventually she decided to bring her enforcement action and argue to the court, he's not doing what we agreed to do.
well, counsel, it seems to me it's kind of a hybrid, right? Based on the unique, setup of this agreement. So if it just said, if the parties can't decide on a school, the court will decide. That's an impasse, right? If it's a shared parenting decision, anytime the parties can't make a shared parenting decision, the court, has to decide that issue. Here you have this kind of pre-decision making procedure, right? Which was non-discretionary and separate from the court's obligation to break an impasse, which was, we will both submit schools in order to tee it up. So it seems to me you have the enforcement issue as to submitting the list of schools. That was an obligation that the parents had under the agreement. And then you have, once that issue is teamed up by their submitting the list, assuming they can't agree, the court breaking the impasse. Is that
I think that's right. I think that's correct. And I think that she brought her motion for enforcement over the former husband's abject refusal, chronic refusal to do what she thought they were both obligated to do in order to resolve their disagreement.
Counsel, are you familiar with case law? And I'm going to touch on this. I didn't see it in anyone's brief, but I'll read you something from the 2nd District Court of Appeal. Where the final judgment reserves jurisdiction to determine school enrollment and the parties are unable to agree on the minor child's school, they are required to obtain a court order on the issue. In such a circumstance, the court must resolve the impasse by determining the best interest of the child. That's from DMJ versus AJT. It's out of the second. There's something similar out of the fifth. What does that mean to you? Why is it different here? Why is that wrong? If indeed you believe it's wrong, my instinct is your argument is that it's wrong.
Well, no, not that it's wrong, but that it goes to one of the two bifurcated parts that Judge Mize just laid out. It goes to the latter part, not to the former part, which was the basis for her motion. She sought enforcement of the act of give me your schools. That's what she wanted him to do, and he refused to do it. That is the basis of the enforcement action. I'm familiar with that case law. There's a handful of cases that kind of echo the same sentiment in holding.
And it's distinguishable in your mind because here we're here on enforcement
Precisely.
and they were there on what?
Precisely. So if
Not
both parents had submitted their schools to the other, then it would be a pure break the impasse. Weigh the evidence, judge. Here's the evidence on these schools. Here's the evidence on those schools. Weigh the evidence, make a best interest determination, and everything is in accord. We didn't even get that far. His father refused to do what the plan ordered him to do.
Assuming school doesn't include homeschooling, refused. So that kind of assumes that the trial judge
Yes.
correctly interpreted that side of the legal agreement. If we disagree with that, if we decide that, a school includes homeschool and the father therefore complied, how do we then resolve the rest of how the trial judge handled the school issue?
Well, there's a lot of implications to think about, but off the cuff, I would say we probably have a reversible order, I would think. Because the basis of the final judgment is such that he didn't perform. He didn't tender a school, and that's because homeschool is not comprehended by the term.
Okay, so if we agree with the father as to the interpretation of the word school that it encompassed homeschool, you agree it's got to go back. Your client can't win after that. There's no other point at which your client can save it.
Boy, do I wish I had more time to think about it, but I think Your Honor is right.
Before we leave attorney's fees, if we suppose we were to decide that you are entitled to contractual attorney's fees, does it make a difference in terms of the current record of the amount of fees? Does it make a difference whether we decided that based on you succeeding in your action to enforce the agreement in the face of an alleged breach, or whether we decide that you succeeded as opposed to Mr. Formica's motion against you to enforce the agreement asserting an alleged breach? Does it matter which motion you went on in terms of what's already in the record? In other words, could we say award Ms. Berger the fees that are already in the record, or would there have to be subsequent proceedings on, to sort of separate them out? Which motion were you litigating or something like that?
Yeah, I do think it's you have to separate. On the current omnibus final order, it's my position, I submit to this court, that Ms. Virgo was the prevailing party on both motions. So you wouldn't have to segregate the amount that's already been proven. It's all encompassed. But if this court were to reverse one and not the other, I agree with Your Honor. You'd have to separate, and there would have to be another hearing.
And let me ask you the same question I asked Mr. Formica's attorney, and that is, how do we interpret when there is a breach of the requirement that you not try to frustrate or control the other parent? In other words, how do we look at an enforcement action that obviously implicates frustrating and controlling the other parent and say, merely filing an enforcement action isn't enough. The parent also has to do X before that parent can be held to have violated the obligation not to seek to frustrate and control.
I think that given the generalized nature of the language that we're referring to, this idea of not to do anything to hamper or frustrate, I think it begs the question, what does that really mean? And I think that's why we have trial judges to interpret it according to what they think it means, given the context. I don't think I could give you a universal answer beyond that, because I do think that it's somewhat loosey-goosey. And it's certainly not, I don't know that it would be contemptible, because it's not as express as one might want it to be. But could it be enforceable? Probably, in the right context. I suppose a hypothetical could be that every time that there's an exchange, mom tells the daughter, don't talk to your father on this visitation. don't do it. You're going to get punished if you come home and I find out you talked to him. I think that's probably sufficient to qualify for an enforcement of that provision. But here, the facts are a lot more nuanced. They're a lot more intimate. This idea that a child is choosing to call a new member of her family by a nickname.
So once the trial court makes a call as to whether the alleged conduct is a violation of paragraph 3.1 or section 3.1, I'm not sure which of those it is. Once the trial court makes that determination, in your mind, is there any reason then to go to the second step of determining best interest, or no, we don't get there at all? We would just determine whether such conduct violates the agreement or doesn't violate the agreement?
No, we don't. I agree wholeheartedly with Judge Mize's recitation of the standards for enforcement versus modification.
Well, so I think it's removed from that,
Okay.
unless you were going to tie it together for me and I'm interrupting you because of that. So, but what opposing counsel has stated is that there was a best interest determination that was required for that issue.
Which issue you're on?
The Papa Kyle issue was my understanding.
Okay.
Do you agree with that contention?
No.
Okay, so that's my question is, so it's your position then that trial court only needs to look at the conduct and say whether that was a violation of the agreement at all and not get to a best interest analysis on that issue,
Absolutely.
on the Papa Kyle issue?
Absolutely.
Okay.
If it's an enforcement question, that's what it is. If the litigant is asking for a change to arise from their efforts, either by adding language or treating language as though it is being deleted by giving it no force and effect, that I think is requesting an implicit modification, and that's impermissible.
Well, I understand that, counsel, but like, this is a general provision. It seems to me whether or not the use of Papa Kyle with the child hampers the natural development of the child's love and respect for the father, that seems to me to be a purely factual issue. So I take your point, it's not a best interest issue. It could still be a factual issue that requires findings. Is this hampering the natural development of the child's love and respect? And I agree that's very general language, but there's no rule that general provisions aren't enforceable, right?
I agree. I would only take a contention, and maybe I'm splitting hairs. I don't mean to do so out of turn, but I don't know that if something is a factual issue, it requires findings. I think it requires competent substantial evidence. So where does that leave us? We haven't had a chance to delve into the verbatim adoption issue, but it seems to me like that's fairly significant because it would mean the undermining of a whole host of things. Is
there any case besides Perlow that binds the 6th District Court of Appeal on what is required in this situation where the trial court asks the parties to prepare proposed orders?
None that I examined. That's all I can say to that.
And I suppose you would argue that the process in this case satisfied whatever Perlow required.
Absolutely. And that's because that essentially, as summarized by the appellate court in West versus West, there are essentially 4 factors to consider whether or not a verbatim adoption of an order should be reversed or not. 3 of which are mandatory, 1 of which is aspirational, permissive. That's the last one. This encouragement, this directive to trial courts to do better, right? Don't set situations like this up. Give your oral pronouncements on the record so that we can rest assured that everything is emanating from an independent basis. But that's permissive, and that's been held to be so, at least by one other appellate court, not precedential in this court. The other 3, the first is, were the litigants both given the opportunities to, it says file, but really exchange proposed orders in advance? Here, the answer is yes. No one disputes that. Number 2, was there an opportunity for objections to be raised and shared and aired? There were 40 days. Neither party's a stranger to filing things in their domestic relations court. The third one was inapplicable. The third one only asked if only one party was invited to submit a proposed order. Was the other given an opportunity to lodge objections? It wasn't our case. And the fourth is the permissive. Trial judge, did you give oral pronouncements? If you didn't, you really should have. We would really want you to, etc. In this case, of the 3 mandatory factors, the only 2 that were applicable satisfied. And that much is not contested.
Does Perlow leave open the possibility that a trial court can nonetheless misstep by making certain oral pronouncements that conflict with what it ends up being in the final order? And if so, why is that not implicated in this case where the judge, I think quite clearly told Ms. Virgo, you were wrong to deny the 2 weeks of vacation based solely on the not providing the dates, on time, you were an hour late. So why is that not implicated here? It doesn't not give that appearance of impropriety.
Absolutely, Your Honor. So the first question you had, I believe, was that might not there be instances where oral pronouncements conflict and where that would jeopardize the solvency of the judgment? I think the answer is yes, and I think that you will find somewhat of a foothold in the permissive factor at the end, the fourth one about oral pronouncements of the Perlow factors. Then the second question was, why isn't that applicable here in the Formica versus Virgo case? And I think the answer to that question is in that portion of the transcript, immediately preceding the judge's thoughts and feelings. And I want to stress the language that was used by the judge to usher these parties' attention to what it was about to say next, because I think that frames the context of what the judge meant. The words were, since I won't have a chance to talk to the parents, I'll just be issuing a written ruling. Pause. Just be issuing a written ruling, not giving my oral ruling and then getting a written ruling. Just. I want to say something to both of you. And this may have some impact, and it may not have some impact. And then it's going to be up to you to decide if what I say is worth implementing or not. That doesn't strike me as the kind of language that a judge who is telling the parties what his or her ruling is would use, but I've never been a judge. That seems to me to be the court wanting to share with the litigants, as it perceived it to be its last time directly with them, to try and share some consideration how they should conduct themselves in the future without rendering a ruling.
So should we read that in your view to be the judge saying whether or not you were legally correct in denying the 2 weeks of vacation? I don't think you should have done that as a matter of prudence or as a matter of wisdom for future relations.
Absolutely. Let me give you some inspirational words for the next time this happens. It would be great if you kind of rose above the language of the judgment a little.
Getting the legal question then, in light of the provision we've already discussed about frustrating and controlling the other parent, and the additional language about requiring cooperation and some flexibility when the schedule isn't practical, or when the schedule is impractical. Why didn't that require Ms. Virgo to forgive the hour and 7 minutes late notification of Mr. Formica's dates?
Absolutely. Bear it in mind, and this is of record, this was the second year in a row that Mr. Formica missed the deadline. The first time he did it, she graciously forgave it, as Your Honor had just mentioned. She forgave it and he got his time. And then 1 year later, he did the same thing again. And she's left wondering, do rules not matter? Does this judgment not matter? What can we do to get Mr. Formica to wake up and follow what he agreed to do? And it's not like, as soon as he missed it again, that she just said, I'm not talking about it. I'm not going to discuss any of it. It's over. As was brought out in testimony, she engaged him in negotiation at her cost, paying her lawyer to do so, to try and come up with a solution. And they weren't able to arrive at one. But that's not doing nothing. That's trying to solve a problem in a confidential manner.
So am I correct that apart from her testimony that she did attempt to negotiate, the actual contents of those negotiations are not in the record, correct?
That's right, in 90.408.
All right, thank you.
Counsel, I have a question. I know you're out of time, but I'd like you to address, is it your contention that the order denying your client's right to attorney's fees, okay, which you have appealed, is inconsistent or irreconcilable with the omnibus order, which your client prevailed under? Is it your position that they're irreconcilable?
The answer is yes, but a little more nuanced than that
Okay.
is only with respect to the denial of fees for her motion over school. And what I mean by that is, and I didn't write this out plainly in the brief. If you read the judge's order on attorney's fees carefully, what you'll find is that, in my opinion, he has misinterpreted the language of the prevailing party fee provision. The judge determined that in order to tee up a right to collect, there must have been a finding in the ultimate judgment that there was a party in violation, that there was a breach of the agreement. That's not what the prevailing party fee provision says. It says that if either party sues the other for an alleged breach of the agreement and prevails, that party is due their fees.
But if the trial court had interpreted it to say no party has sued another party for an alleged breach at this moment in time, they would be reconcilable. Is that correct?
I'm sorry.
That's okay. So say we change the trial court's ruling, right? So hypo. So say the trial court had found no party is entitled to prevailing party attorney's fees in this instance because no one at this moment sued the other side based on an alleged breach. Say he had said that. Wouldn't those orders then have been consistent? The omnibus and the fee order.
If what you're getting at is that we're taking the definition of suit to mean a petition or a complaint as opposed to a motion, or
well, I don't know. I'm trying to figure out the different worlds in which these things might be reconcilable. I see the word alleged. I understand your point that you made in the brief and that you're making to me now, that the word alleged is here and that the trial court doesn't harp on the word alleged, right?
right,
Focuses on breach.
and there must be a finding of breach, or that there must be a breach, and that's not the standard.
Right, and I read that as well. But when so it seems to me that if you look at sues, I mean, aren't we having to read that word out in order to find that these two decisions would be irreconcilable?
Your Honor, just as I would say to Judge Mize, if I had anticipated the argument, I've looked into the definition of sues and determined that it wasn't applicable to a motion, we wouldn't have gotten this far.
Have you all been receiving prevailing party attorney's fees awards in this case as you file motions, or maybe no such motions previously?
There had been no such
So this is a first instance.
in this case, yes.
Okay, all right. Thank you, counsel.
Thank you, counsel.
Thank you.
All right, counsel, you have 4 minutes for rebuttal because we gave appellate's counsel a couple extra minutes.
Thank you, Your Honor. Your Honor, I just want to focus on the issue of the verbatim adoption of the court's ruling and Mr. Shemkis's assertion that the court's statements at the end were mere musings. And I agree with Mr. Shemkis in that the Perlow basis, and that is the only binding case law at this time because of the new creation of the 6th DCA. I agree that the 4 steps are correct as Mr. Shemkis identified. And I agree the only one that the judge didn't do, which was one that was one of encouragement, was to make explicit findings over every issue, though I think his assertions at the end could amount to some indication of how his ruling would be. I acknowledge he didn't explicitly say these are my findings. He also didn't explicitly say these are not my findings.
How many days was it, counsel, between the time that the proposed orders were submitted and the time of execution or not rendition of the final order, but the time he signed it? Was that 40 days?
I think 40. Yeah.
So, yeah, go ahead. No.
Counsel, I read those words. I think they could reasonably be read to mean that the trial judge thought the mother should have given the father the 2 weeks vacation as a matter of discretion, rather than that she violated the parenting plan by not giving the 2-week vacation. I mean, it's not uncommon for judges in family law cases to ask the parties to kind of look beyond merely their legal obligations to be good co-parents and to improve their relationship, and for the benefit of their child. And so it wouldn't be shocking to me that a trial judge might say, listen, no, he didn't violate, maybe he violated the agreement, but it was an hour, and I really think, ma'am, you should think about whether, it would have been good for your co-parenting relationship and your child for you to give it anyways, right? Inspire the parties to do better, right? I didn't see anything in there where he said, I think the mother violated the agreement by not giving the 2 weeks. Or that the father didn't miss the deadline. I mean, what he actually said, if you look at the words, is not in conflict with his order. He never said the father didn't miss the deadline or that the mother violated the parenting plan by not giving the 2 weeks.
That's also part of why it raises the question of whether or not he exercises independent judgment. Why isn't any mention of it in there at all? Why wouldn't the court make any type of revision to a 31-page order that is strongly against the father on every single issue?
Well, whether or not the court, I take your point that he didn't make any revisions, but that's a completely separate issue from whether the order was in conflict with what he said in court. I mean, those are two separate arguments. And in your brief, you said you think they were in conflict. And what I'm telling you is I read them and I don't see the conflict. Telling a mother, hey, you didn't have to give him the 2 weeks, but I really think maybe as a matter of co-parenting and having the best relationship your child can have with both parents, you might think about whether or not you should go above and beyond your obligations in the parenting plan. That's not an uncommon thing for judges in family law cases to discuss. And so in order for them to be in conflict, right, I would need to see a comment from a judge that says, I don't think the dad missed the deadline, or, I think the mother did violate the parenting plan by not giving him the 2 weeks. And those words don't appear in what he said.
I think the conflict is in that the judge additionally stated that I think it would have been in the best interest of the child to provide the father with vacation. And there's no best interest analysis at all.
But that assumes you need a best interest analysis for an enforcement proceeding, doesn't it?
Yeah.
Anyone have any other questions?
I'm going to ask along the lines of the deadline, the May 1st deadline. It's argued that by Mr. Formica that the parenting plan requirement for flexibility and cooperation and scheduling, should have, essentially sort of excused or forgiven that, that hour and 7 minute, tardiness. But as I read 3.1, it also says the parents understand they're free to vary the times or days. They just have to put it in writing, but absent something in writing, they're bound by the schedule laid out in the plan. So my question is can we really allow Mr. Formica to avail himself of this flexibility and cooperation provision if he did not say, maybe even on the 1st or at some point, hey, I'm going to need some extra time to give you my days. Will you, bear with me for a day or two? In the absence of that, additional requirement that they talk about it and put it in writing, can he really, claim that the mother wasn't flexible or cooperative in dealing with that particular deadline?
I think under these circumstances, yes, I could see the circumstances where I would say no. I think given that it was an hour in the middle of the night, it was, I think, 1:06 a.m. when he sent the notice. It's clear from this record he nearly forgot and then sent immediately. I think, had it been days later and he didn't say something like, you give me an extension, I would agree that he's also not being active in seeking what he's entitled to in the agreement.
So should we, as I understand it, and correct me if I'm wrong, but you're saying we should interpret this to allow some wiggle room with the deadline, like the May 1st deadline. 2 days probably would be too much, but an hour and 7 minutes is within that requirement for flexibility and cooperation.
As I've heard it stated by judges, I don't have a case in front of me to state this, but as I've heard from judges, parenting plans are supposed to be bendable in some respects. We're talking about children, and strict adherence may not always be in the best interest of the child. And so the parties are expected to somewhat cooperate with each other. And I think that language in there that says shall not frustrate the other parent's rights under these circumstances, this hour delay was doing exactly that. And as the record, there was a citation in my brief to the record, it was the judge interpreted what she was doing to essentially not necessarily punish, but teach a lesson. Yes, yeah. And that wasn't appropriate under the circumstances.
Thank you, Councilor. Time's up.
Thank you.
Court will be in recess.